Hello and welcome to this FedSoc Forum webinar call. Today, March 7th, 2024, we're delighted to host a litigation update discussion on Speech First versus SANS. My name is Kayla Kleist, and I'm an Assistant Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the experts on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, I will keep my introduction of our guests today quite brief, but if you'd like to know more about either of our speakers, you can access their impressive full bios at fedsoc.org. Today, we're fortunate to have with us Abigail Smith, who is an amicus attorney at the Foundation for Individual Rights and Expression, FIRE. Ms. Smith joined FIRE after her tenure at the Becket Fund for Religious Liberty, where she litigated First Amendment student group cases from coast to coast. She also has worked as a trial litigation boutique, in Southern California. Ms. Smith has filed briefs on the First Amendment in state and federal court at the trial and appellate court levels, including before the Supreme Court. She's admitted to practice in New York and California, as well as several federal appellate courts and the U.S. Supreme Court. Also joining us today as our moderator for today's discussion is Tyson Langhofer, who serves as a senior counsel and director of the Center for Academic Freedom with Alliance Defending Freedom. Before joining ADF, Mr. Langhofer was a partner with Stinson LLP, where he worked as a commercial litigation attorney from 2000 until he joined ADF in 2015. He regularly comments on free speech issues in television, radio, and print media, and has appeared as a guest and written pieces for numerous major media outlets, including The Washington Post, The Washington Times, USA Today, Town Hall, Federalist, and The Daily Wire. Mr. Langhofer is admitted to practice in multiple states, the Supreme Court, and before numerous federal, district, and appellate courts. And I will leave it there. One last note throughout the panel, if you have any questions, please submit them via the question and answer feature found at the bottom of your Zoom screen, so it'll be accessible when we get to that portion of today's webinar. With that, thank you all for joining us today. Mr. Langhofer, the floor is yours.
Thanks so much, Kayla. And thanks everybody for joining us for this really important and interesting discussion on an important case that really kind of has impacts nationwide. And I'm really appreciative of Abby joining me today, because she's with FIRE and ADF. We've joined a lot of the cases that are going to be at issue here and fighting against kind of the same thing. So I'm going to give a brief overview of the case, and then we'll jump into questions from Abby. So the case is Speech First versus SANS, and that involves a challenge by Speech First, which is a campus rights, speech rights organization, and it's challenged to a bias response team policy and program that's at Virginia Tech University. And so they filed a challenge to this on behalf of Speech First in the Western District of Virginia. It then went up to the Fourth Circuit and then recently to the Supreme Court. And we'll kind of talk about those procedural developments here as we go along. But since most people, these bias response teams are relatively new, and they may not have been around when all of us went to college. Abby, why don't you tell us a little bit about, kind of before we get into the facts of the case, what is a bias response team, and kind of what are the hallmarks of some of these things that are going on across the country?
Sure. So first, I'll give a formal definition of what a bias response team is, and then I'll explain what that actually means in the real world. So people define them differently, but at FIRE, we've defined a bias response team on a university or college campus as any system identified as such, or that provides 1, a formal or explicit process for, 2, reports from students, faculty, staff, or any community member at the university, 3, that concerns offensive conduct or speech that is or would be protected by the First Amendment. So again, that's kind of very legalese, but what it looks like on the ground is many colleges and universities that have these bias response teams, they will have a group, the team made up of often a number of university administrators, such as the dean of students. They may involve university police members, they may involve students or other professors, and they will actively encourage other students, faculty, people on campus to make reports to the bias response team anytime they think they see someone doing something offensive. Oftentimes those reports can be completely anonymous, so whoever is accused of doing something offensive has no right to face their accuser. When you are reported to the bias response team for doing something that may be offensive, that someone thought was offensive, you are usually called into a so-called voluntary hearing with the bias response team or a member of the bias response team. And they say, well, you don't have to come to this hearing, but just so you know, we will probably meet anyway, and you could be subject to serious disciplinary sanctions up to and including suspension. And the worst part is that the definition of what can be reported as being offensive is incredibly broad and captures a lot. In fact, I would say the most of the activity captured by bias response reporting systems are protected by the First Amendment. So it can cover things that may not be protected by the First Amendment, such as, you can report sexual assault, but you can also report someone for crude jokes, throwing a Cinco de Mayo party because that is culturally offensive, having an Israel or Palestine flag on your dorm room door. It covers such a broad range of expression that is absolutely protected by the First Amendment, and it chills student speech.
So essentially, a bias response team is designed to encourage students to report potential concerns that they have with other students' conduct, which also could include speech. And it doesn't necessarily just target unprotected speech. Is that essentially right?
Absolutely. And you say that it targets conduct, which can bring in speech. Every university's policy differs in the details. Many of them expressly target speech itself. Obviously any public college or university that has one of these bias response teams and these policies where they're encouraging students, professors, other community members to report, they're basically encouraging people to report their peers on campus for activity speech that is protected by the First Amendment. And it leads to a lot of self-censorship, which is obviously a rising problem nationwide on campuses.
So are these policies limited in the context of where the speech occurs? Like, does it cover speech in class? Is it limited to on-campus speech, social media, that kind of stuff?
It really depends, but for the most part, they're incredibly broad. They've been used to target professors for teaching things in the classroom. One professor was called in under a report to his school's bias response team and told that he should not teach anymore about transgender rights in the classroom because a transgender student in the classroom was offended. It can also target social media posts. We know of a case where there was an anonymous Instagram post that made a Build the Wall parody about the university, and the university investigated who had posted that. It's things you say in your dorm room. It can be off campus. It's really anywhere, as long as that person is a student of the university or a staff member or a professor there.
So how common are bias response teams on college campuses throughout the country?
It's hard to put an exact number on it because different organizations define a bias response team differently, but we do know that they're very common and they're becoming much more common. So FIRE did a survey on bias response teams in 2017, which was kind of when we saw the first initial waves of university administrations adopting these bias response systems. And at that time in 2017, we found that there were 231 colleges and universities in the US that had them, which covers about 3 million enrolled students. Since then, in 2022, Speech First did their own follow-up survey. It's not exactly apples to apples because the definition of bias response team was slightly different from FIRE's, but at that time, they found that in only 5 years, the number of colleges and universities with bias response teams had more than doubled to over 450. So it's a big problem, it's getting worse, and it's covering millions of students with these self-censoring policies.
Yeah, it's interesting that, as we'll talk about, Speech First has challenged these on a number of universities across the country over a number of years. And yet, even though many of those challenges have been successful, as we'll talk about, that actually more, the number of bias response teams is growing, not, diminishing. So that is a concern. So let's talk about the plaintiff here. Who is Speech First? What's their mission?
So you mentioned this a bit in your intro, but Speech First is a membership organization. Their organization is comprised of members who are current students at colleges and universities, alumni, and other people who are generally supportive of free speech. And their mission is to kind of go after colleges and universities that are restricting freedom of speech on campus in ways that violate the First Amendment. A big part of Speech First legal strategy thus far has been suing public universities over their bias response teams, and that is what's at issue in this lawsuit against Virginia Tech.
Okay, yeah, as you just mentioned, they have mounted a number of challenges, and I think it's important to kind of lay the landscape of the litigation prior to this Virginia Tech case, the Speech First versus Sands case we're going to be talking about, because that kind of sets the stage for the eventual case in the Supreme Court. So tell me about the challenges, and kind of in general summarize the challenges that Speech First has made against bias response teams at other universities, and kind of the outcome of each one of those challenges.
So thus far, over the last about 5 years, Speech First has challenged bias response teams at, I believe, 6 different universities. So they've challenged them at the University of Texas, the University of Illinois, University of Michigan, University of Central Florida, Oklahoma State University, and here, Virginia Tech. And their results have been fairly split. They've had a lot of success, but they've had a couple of losses as well. So in their lawsuits against the University of Texas, which is in the Fifth Circuit, University of Michigan, Sixth Circuit, and University of Central Florida, 11th Circuit, they won. Essentially, in all of those cases, they filed preliminary injunction, and the circuit courts of appeal held that the way these lawsuits turn out, the schools often challenge them based on standing, and they say you have no standing as a membership organization to sue because actually what we're doing does not chill speech. So it's a standing argument, but it's actually a First Amendment argument kind of masquerading as a standing argument. So all the Fifth, Sixth, and 11th Circuits all held that the bias response team policies at those schools did objectively chill speech of students and faculty on campus, and would lead an objectively reasonable student or faculty member to self-censor, which violates the First Amendment. Therefore, they had standing to sue, and Speech First won in those 3 lawsuits. In their lawsuit against Oklahoma State, it's actually still ongoing, so kind of to be determined. Initially, the district court in Oklahoma did dismiss the case, or I believe reject the preliminary injunction, because he did not believe there was a First Amendment violation and there was no standing, or I'm sorry, that was because of an issue with anonymous members. But the 10th Circuit reinstated the lawsuit. So the Oklahoma State lawsuit, kind of to be determined what's going to happen there. And then in Speech First versus Killeen, which was this lawsuit against the University of Illinois, the 7th Circuit held that Speech First did not have standing to sue. So they held that, in their view, bias response teams did not chill speech objectively. And so therefore, they believe that Speech First had no standing. And then in this case, which we'll talk about more in a minute, the 4th Circuit essentially adopted the 7th Circuit's reasoning in Speech First v. Killeen. So those are, it's about 3-2 and 1 pending.
Okay. So 5th, 6th, and 11th have all held that the response teams did chill speech objectively, and that they had standing to challenge that. And then the 7th, and as we'll talk about the 4th, held that that speech was not chilled, and therefore no standing. Now, and I think it's true that each one of the requests for injunctions in every one of the district courts, those were denied in every district court. Do you recall? Am I correct in that? Do you remember?
I believe that is correct, but given that there were 6 of them, I can't affirm for sure off the top of my head.
Sure. Okay. All right. So that gives us a good framework for understanding where the state of the law when it came to the challenge at Virginia Tech. So now let's talk kind of about the specific facts of the case. tell me about Virginia Tech's bias response team policy and what speech first is. What's the challenge that they're bringing in this case?
Sure. So as university bias response systems go, I would say Virginia Tech's is definitely on the more extreme, strict side. And that's kind of in part due to the history. I believe that Virginia Tech first started implementing policies to do with bias response in the wake of the Virginia Tech shooting in 2007. So there's an understandable desire to try and prevent those kinds of things from happening, but oftentimes that can lead to an overreaction, or at least I would say going too far beyond the bounds that the First Amendment will permit. So the specific policy here with Virginia Tech's bias response team, it deliberately targeted speech as speech. So its campaign slogan for the bias response team on campus was "See something, say something." They took it from the Department of Homeland Security. They defined a reportable bias incident as any expression, so most expressions are speech, against a wide variety of groups based on a wide variety of characteristics like race, gender, sexual orientation, political affiliation, or disability. It gave one of the things that was perhaps so jarring about the Virginia Tech policy was that it gave specific examples of what types of incidents would qualify as a reportable bias incident. And that include things such as jokes that are demeaning, a fraternity holding a date auction or a slave auction, hosting a culturally themed party like a Cinco de Mayo party, or posting flyers with demeaning language or images. All of those things are protected by the First Amendment at a public university like Virginia Tech. And that was the basis of Speech First's lawsuit.
Yeah, so and those examples you cite, those were actually written examples in the policy in order to.
Yes, exactly. Those were written examples those are not hypotheticals raised by Speech First in the litigation. Those are in Virginia Tech's policy. If you make a demeaning joke or if you host a culturally themed party, you can and should be reported for a bias incident, which will then result in a referral to the bias response team.
Yeah. So in other words, these students, when they're reading about it, they'd see that and say, oh, yeah, I heard that fraternity was doing something. They want me to report that. It's not like I'm just subjectively thinking that type of thing would be covered by it, because they've actually said it is covered by it.
Exactly. And like I said, they were actively soliciting students to make these kinds of reports with their See Something, Say Something awareness campaign.
Okay, so that kind of so what happens? What do you have any more discussion about kind of the procedure of after somebody makes a complaint, after a student makes a complaint, what happens after that?
So often when a student makes a complaint, they will receive a letter from the bias response team asking them to come to a voluntary hearing. I believe the bias response team at Virginia Tech included the dean of students, who has the ability to kick you out of student housing. It included members of the university police force. So you're going before a hearing with police members and several other community members at the university. Now, while technically you do not have to attend the hearing, it's obviously the cloud hanging over you, and they do inform you that you could be subject to sanctions. So while the bias response team itself cannot formally issue a sanction, the bias response team, for example, cannot give you a suspension or force you to attend cultural awareness training. They can make referrals to other parts of the university, including to the police department, that you receive sanctions. So even though the bias response team can't directly punish you, it's all the most important decision makers in the room telling other parts of the university that they should sanction you. So even though you don't have to go to that hearing, obviously a student who gets one of these letters is going to be pretty terrified about what happens if they don't go.
So what was in the complaint itself, Speech First, did it allege that any of its members at Virginia Tech had been punished by the bias response team? And if not, what were the allegations that they were saying? What was the harm they were alleging?
So this was a big part of the discussion in the district court and the Fourth Circuit, which both ruled against Speech First. Speech First did not allege that any of their members had already been targeted by the bias response team and had been punished. Rather, they had student members who said that they would like to say things that would probably fall under the bias reporting incident policy, but they were too afraid to say things that they wanted to say that they're completely within their First Amendment right to say on campus, because they were afraid that it would offend other people, that those people would report them, and that they would then be called in by the bias response team. So they basically alleged that they were self-censoring because of the existence of the bias response team.
Okay, so there was no actual application of the bias response team to any of the members, the students at Virginia Tech, but they did specifically allege that the students at Virginia Tech, which are members of Speech First, wanted to engage in certain discussions that they believe, based upon the kind of the definition of a bias incident by the university, could subject them to being reported, and therefore they're not gonna, they've declined to engage in that type of speech. Is that accurate?
That's correct.
Okay. So before we get into the district court's ruling, I know that, because this is going to be a big discussion about, the district court. I know FIRE's done extensive research on bias response teams across the country. Can you give me some examples of how those bias response teams are applied, and explain why FIRE believes that they are actually chilling speech? Because that's a lot of the discussion that goes on at the district court.
Absolutely. So at FIRE, we believe they're chilling speech because we have several examples where they did literally punish speech and chill speech, not that are the subject of these particular lawsuits. But for example, I referenced this earlier, but at the University of North Colorado in 2016, a professor was reported to his school bias response team for discussing transgender rights in the classroom. He was called in by the bias response team, and another faculty member told that professor, do not talk about controversial subjects, including transgender rights, during class at all for the rest of the semester, because they were afraid that the offended students would file a Title VII or a Title IX lawsuit. So they told a professor expressly, who had been reported to the bias response team, do not talk about this even in your own classroom, because we don't want to get sued. Similarly, at the University of New Mexico in 2013, there was a big public debate at the Student Senate over whether to ban Chick-fil-A from campus because of positions taken by Chick-fil-A's founders. And during the debate, the president of University of New Mexico Republicans stood up and criticized another student and her organization for wanting to kick Chick-fil-A off. We have the bias response team logs. I believe we FOIA'd them several years ago. That student filed a bias response report to the school solely on the basis that at a public debate, a Republican student complained that a Democratic student wanted to ban Chick-fil-A. Similarly, at Colby College, again, we have the bias response logs, we've got the paperwork. A student was reported for claiming that a different student organization was racist against white people. And another student was reported for being ableist because he used the phrase, on the other hand. This is the kind of innocuous, unintentional statements that are being used to call people in to bias response teams. And then one last one that I again referenced earlier, at Wake Forest University in 2019, an anonymous Instagram account posted a meme saying there's another university in the same town called Winston-Salem State University. And they posted a meme that they were, it's 2019, President Trump was president at the time. They said that they would build the wall between Wake Forest and Winston-Salem State University. And then one of the deans of Wake Forest University publicly announced that they were going to launch an investigation under their bias response policies to find out who posted this meme. So all of these statements are clearly protected by the First Amendment when they're at public colleges and universities. And some of them, like, on the other hand, aren't even remotely offensive. So when you as a student know that you can be reported for something as benign as, on the other hand, speech on campus is going to be chilled because there's always someone listening and you never know what's going to bother a university administrator.
Yeah, and actually, one of the facts I think that were alleged in this case, reported to Virginia Tech, was that somebody had seen the words Saudi Arabia on a board in a dormitory. There was no comment about it, but that was reported
Yes.
as well, right? And investigated as a bias incident when it could have been a discussion about Saudi Arabia just in general. It wasn't necessarily targeted towards anybody. And so, yeah, it does demonstrate the kind of the breadth of the types of complaints that students believe are covered by this. And then, in fact, that the university then has a kind of an obligation to investigate. So, okay, well, that gives us a good framework for understanding the basis of the challenge. And so what happened at the district court? Did the Speech First, they filed a complaint, and did they also move for preliminary relief? And if so, what did the district court rule?
Yes. So in this case, Speech First followed the kind of similar plan of attack that it did in the other lawsuits. It filed its complaint against Virginia Tech and then sought a preliminary injunction. The district court denied the preliminary injunction. It held that Speech First lacked standing because while Virginia Tech's bias response team can recommend students for sanction or discipline by referring out to other university departments, the bias response team itself lacked authority to individually issue discipline or otherwise punish students. And so they have found, the district court held that because it was merely a referral power and not a direct punishment power, that there was no First Amendment violation from the bias response team itself, and therefore that Speech First lacked standing. And in doing so, it acknowledged that the Fifth and Sixth Circuits at the time, because the 11th Circuit hadn't ruled yet, it acknowledged that the Fifth and Sixth Circuits had ruled completely the other way, but said that it found the Seventh Circuit's ruling and reasoning in Killeen more persuasive, and so denied the preliminary injunction.
Okay, so and explain to me, did the district court address the issue of organizational standing that Speech First could file on behalf of its individual members, and what did it address that, and is that standing that Speech First has?
So I believe that in this case in particular, so that's an issue that's come up in particular in the kind of Oklahoma 10th Circuit case. But I believe here, I don't recall exactly the district court, but I do recall that the Fourth Circuit held that if there was a violation, then there would be standing. So there was not an issue with the anonymous member organizational standing in this case, like there was in Oklahoma in the 10th Circuit case.
Okay, yeah, and I know that's come up in some of the other Speech First cases. They've addressed it, and I do believe that that's correct. That here in the Fourth Circuit, the Speech First had organizational standing, so they could bring a First Amendment claim on behalf of its members. The question is, did the allegations themselves, did they arise to grant standing for that alleged violation? And the district court, you said, indicated that did not have standing because the allegations of chill were not sufficient to show an injury in fact. Is that right?
That's correct. And that's kind of what thank you for making that clearer. That's kind of what I alluded to at the beginning. All of these cases are presented as standing cases, but it's really a First Amendment case wrapped in a standing case, because the only way to have injury in fact is if the policies alleged are actually chilling. Because in all of these cases, I believe there's no member of Speech First that had actually been punished by Speech First. Rather, they were all self-censoring because they were afraid of being punished. So therefore, if the policies don't objectively chill speech and violate the First Amendment, there is no injury in fact, and thus there is no standing.
Which is why that you can see these denials of preliminary injunction appealed directly up to the circuit court, right? Because it really presents the substantive issue, to the circuit court. Is this policy on its face a violation of the First Amendment because the policy itself chills speech. Is that accurate?
Exactly. There's no need for factual development on these cases because they're all facial challenges. So it does allow them to go up the appeal chain fairly quickly.
Okay, so district court looks at this, denies the preliminary injunction, says there is no injury in fact, and what happened next?
Speech First appealed to the Fourth Circuit, and the Fourth Circuit completely agreed with the district court with a dissent from Judge Wilkinson. So the Fourth Circuit agreed that the Speech First had no standing because there was no injury in fact, because Virginia Tech's bias response team did not have direct authority to discipline or otherwise punish the students. So therefore, in the Fourth Circuit's view, no reasonable student would self-censor for fear of being reported to the bias response team. Unfortunately, the Fourth Circuit went even further and actually praised Virginia Tech's bias response team as a, quote, model way to educate the student body about harmful stereotypes, discriminatory tropes, and the role of tolerance in the campus community. That holding completely ignores the fact that the expression of such stereotypes and tropes are almost always protected by the First Amendment.
Okay, so the Fourth Circuit affirmed the district court and held that there was no standing, but you said there was a dissent. Talk about the kind of the different positions. Where's the real kind of conflict between the majority's position and the dissent on the issue of standing?
So Judge Wilkinson wrote the dissent, and he essentially adopted the reasoning of the Fifth, Sixth, and 11th Circuits in those Speech First cases. He said, it's clear on its face that this would lead to self-censorship. He did not have an issue with the fact that the bias response team technically couldn't punish itself, that could only refer them out to punishment, because in his view, it's not just the punishment that is the problem. It's that there is what he called a, quote, regime of comprehensive surveillance at Virginia Tech that resulted in a complex apparatus for policing and reporting whatever the administrators may deem biased speech. So it's not just the punishment power that is violating the First Amendment here and chilling speech. It's the fact that there's always someone watching. See something, say something, right? He believed that the chilling effect of the bias response team was evident on its face and would clearly cause reasonable students with unpopular opinions to self-censor.
So you talk about this kind of reasonable, would chill a reasonable student or cause them not to speak? I mean, can you talk about, because it is different. I mean, typically when you're talking about a First Amendment violation, you're talking about a government official or a government policy who says to a specific individual, you can't speak, right? You can't say that, or you don't have a permit. I'm going to deny this permit to speak. And that's a more clear violation, right? But the First Amendment also addresses, and the Supreme Court has addressed, sort of this a policy which didn't deny a permit, didn't say you can't speak on that, and didn't specifically punish any speech, but causes people on their own to not speak. So what's the standard for kind of chilling speech in general?
So one of the best Supreme Court cases on this that describes it is called Laird v. Tatum. And that case held that, like you say, the obvious First Amendment violation is when someone says, no, you can't speak. But there it said that even where no one is kind of what they call, where there's no direct prohibition against the First Amendment rights, so there's no obvious ban on speaking, the government can still violate the First Amendment if they have a system of regulations or policies that, such as aggressive data gathering or monitoring or surveillance, that ultimately would deter, or the term they use, which we've used throughout today, if they objectively chill speech. So if someone is not technically being banned from saying something, but if the government has imposed such a restrictive regime of kind of data gathering or surveillance or reporting that what they use an objective standard, any objectively reasonable person would be chilled, would self-censor themselves for fear of being targeted should they express speech that is protected by the First Amendment.
So here, Speech First did allege that its students were declining to speak because they were afraid that they'd be punished. Is that right?
That's right. But the Fourth Circuit was not convinced. Whether the Fourth Circuit said that no reasonable student should be self-censoring, even though I guess the implied message is that the students were unreasonable for self-censoring, because even though they could be referred to the bias response team for a hearing, they could always just refuse to go. And it's not like the bias response team itself can sanction the student. They will merely tell someone else at the university to sanction the student. So the Fourth Circuit just didn't think the concerns were reasonable. But I think Judge Wilkinson very artfully outlined, how a teenager or early 20s college student, where if you get expelled, that is the end. It's very hard to go to another university after that happens, kind of explaining the pressure and the chilling effect of the mere existence of this, especially given how easy it is to report such a broad range of speech to the bias response team at Virginia Tech.
So both the majority and the dissent essentially recognize that a policy can be unconstitutional and can be facially challenged if it chills speech. It's just that what they disagree on is whether this policy itself is so overbroad that a reasonable student would, in fact, be deterred from actually, engaging in speech. Is that fair?
That's correct.
Okay. So we have a split 2-1 decision at the Fourth Circuit. After the Fourth Circuit's ruling, Virginia Tech actually did something which you and I have seen a lot at ADF and Fireboat. They eliminated its bias response team. So this is kind of surprising, right? They won at the district court, they won at the Fourth Circuit, and yet they eliminate their bias response team before Speech First could appeal to the Supreme Court. So that really kind of set the stage at the Supreme Court. In fact, providentially, the court just ruled on the Speech First's petition on Monday of this week. So, so when it went to the Supreme Court, where it was at that time was the Virginia Tech had won, but they had done away with their bias response team. So what happened after this Speech First requested that the Supreme Court rule on their petition for cert?
So on the eve of Speech First cert petition being filed, Virginia Tech revoked all of their bias response team policies. And thus, when Speech First filed their petition for certiorari, when Virginia Tech filed its response, the vast majority of their brief was saying nothing about the merits of the First Amendment challenge, but rather saying, Supreme Court, this case is moot, and you should moot this case because the policies don't exist anymore. Unfortunately, the Supreme Court agreed to do that. So like you say, on Monday, the court, it's kind of procedurally interesting, but the result is the same. So the court did grant certiorari of the case, and then they used that to vacate the ruling of the Fourth Circuit. So the Fourth Circuit's ruling is gone, and they remanded the case to the Fourth Circuit, instructing the court to dismiss all of Speech First claims against the bias response team as moot under a case called United States v. Munsingwear.
Okay, interesting. All right, so where it currently stands as of now is there's a 3-1 split, right? Is it you've got the 5th, 6th, and 11th ruling against it, and then you've got the 7th ruling, that bias response teams don't. But now that the Fourth Circuit opinion that on the merits is vacated, so is it just now a 3-1 split, kind of?
Yes, kind of. It's a bizarre procedure. It's an unusual procedural posture, that's for sure.
Okay, so you mentioned Munsingwear. What is that case and why is it important here?
So United States v. Munsingwear is a Supreme Court from the 1950s. It basically held that when you have a appellate court ruling and you're appealing it to the Supreme Court, but in the process, the case is mooted. So in that case, they were there was a challenge. The United States was going after someone for a regulated commodity, and during appeals take many years. The regulation that regulated that commodity disappeared. So the court ruled that when a case is mooted when there's already a appellate ruling against it, but it's mooted on its way to the Supreme Court, that the court should not grant and hear the case, but rather they should grant certiorari and vacate the judgment below, then order the case to be dismissed. So that way, there's no precedential judgment against the appealing party below. So if a problem arises in the future and they want to file a new lawsuit, there's no res judicata issue. So
Okay.
that's why you vacate the Fourth Circuit ruling. So that way there's no res judicata problems, even though they can't appeal to the Supreme Court now.
So technically, if Speech First wanted to file a case against a university in the Fourth Circuit, it's kind of appealing in a universe in which this opinion doesn't exist, basically.
That is technically true. However, I think you and I have both seen that whenever something like this happens, the Fourth Circuit will just say, well, while this case was vacated, it was not on the merits, so we're going to adopt the holding there. So I think it's very likely if another Fourth Circuit case is filed against a bias response team, the court will, unless Judge Wilkinson is in charge and has two friends on the panel, the court will likely readopt its ruling here.
Okay, so Supreme Court grants cert, reverses, it vacates it as moot and sends it back down. Was there any dissents from the denial?
Yes, there were 3 justices that dissented. So first was merely a one-liner from Justice Jackson. She would have just denied the petition. She would have left the Fourth Circuit's ruling intact. Justice Thomas, joined by Justice Alito, would have granted the petition, and they would have heard the case to address whether bias response teams are constitutional. So they did not think that the case was moot because of the doctrine of voluntary cessation, which I know we're going to talk about in a minute. As to the merits, they said they had, quote, serious concerns that bias response policies such as Virginia Tech's objectively chill student speech. They said they were skeptical of the Fourth Circuit's ruling. They talked a lot about kind of the breadth and scope and enforcement of the bias response policies at Virginia Tech and how concerning they were, specifically the incredibly low bar to report an alleged bias incident and the hefty consequences. So they would have heard the case on the merits.
So it sounds like they essentially kind of adopted Judge Wilkinson's views and sided with the fact that they believed that this policy does, in fact, would cause a reasonable student to not speak for fear of being reported. That's
correct.
Okay. So yeah, you talk about voluntary cessation. That's something also that ADF and FIRE are very familiar with. And it's, you can litigate a case for many years and then be faced with a very different set of facts once you get up maybe to the Supreme Court or the Court of Appeals. So tell me about the voluntary cessation doctrine and how that comes to play in this case and then maybe many other, university cases.
So the voluntary cessation doctrine basically says that when the government decides, especially during the course of litigation, when the government decides that whatever regulation or law they have that's being challenged, they're just going to, especially if it's a regulation, I believe, they just decide to revoke it in the middle of the lawsuit, but they could bring it back at any time. That in such cases, the lawsuit is not mooted because, as you and I have seen several times, especially suing universities, oftentimes a university will keep a policy in place until they think they're going to lose. And then they will suddenly revoke the policy and say, okay, this is moot, the case should be dismissed. The problem is there's nothing stopping them from putting that policy back in place even 6 months later, or, if they're being disingenuous, or even where, they truly want to get rid of the policy, university administrations change all the time. So we've seen, a decade later, a university will bring something back that a prior administration agreed to get rid of for violating the First Amendment. And so it just, without the doctrine of voluntary cessation, it's incredibly easy for governments, especially colleges and universities, to moot out cases when they think they're going to lose, and then just bring those policies back when they think everyone has forgotten about it. And then you have to go through the hassle of having a whole new lawsuit. So this came up in other Speech First challenges. This came up in its Fifth Circuit case, Speech First v. Fenves. I believe it also came up against Michigan, Speech First v. Schlissel. And both the Fifth and Sixth Circuits there said no, under the doctrine of voluntary cessation, just because you revoked this bias response team policy does not mean the case is moot. So it was disappointing to see the Supreme Court here adopt that reasoning.
Yeah, I mean, I think, and this is a really interesting case, and it shows kind of the difficulties with litigating this, because in the Fifth and Sixth, those universities had lost, right? And they had lost, and they were, kind of taking away the policy kind of prior to the ruling. Whereas here, they won at the Fourth Circuit, and then they took it, they did away with the policy afterwards. And I think one of the things that's interesting to me is, you have a university who's adopting this policy, has maintained it for a long time. They fight for the constitutionality of it for many years, and say that not only it's constitutional, but it's necessary for us to achieve our mission. And yet, when faced with the thought of we might lose, they then, take it away, right? And I think that's one of the problems is in litigating these, especially for students who are only there for a couple of years. They lose a couple years of their life on campus while the university's fighting this, and then all of a sudden, the university changes their tune and pulls a policy.
Absolutely. The student plaintiffs have a kind of unique disadvantage in challenging these policies because, like you say, they're only there for 3, 4, or 5 years. A lawsuit, especially going up to the Supreme Court, can take well over 5 years. In fact, I would say it would be unusual for a case to get to the Supreme Court in less than 3 or 4 years. So, especially if it has factual development. So, it's already very difficult for students to challenge these university policies, and then to allow them to be mooted. Those students who know that the policy is wrong will graduate. So there's no institutional memory. And therefore, several years later, it's easy for a university to readopt those policies. We have seen this happen several times at FIRE. And so FIRE kind of has the institutional memory because we have written letters in on behalf of student groups multiple times against the same university. But it's very challenging. And that's why the doctrine of voluntary cessation is so great to kind of prevent these abuses from happening, and why it's somewhat disappointing that it wasn't invoked here.
In fact, in this case, speaking of students graduating, I think all of the original members that Speech First relied upon when they first filed the lawsuit had graduated by the time it got to the Court of Appeals, and they had to supplement the record with some additional members and affidavits in order to continue their standing there. So it does demonstrate the difficulty with maintaining these. So, all right, so where do we stand? Where does the law currently stand, basically, with respect to bias response teams on college campuses?
So I would say it stands exactly where it did a year ago. It's very up in the air, depending on geography. If you live in Florida or Michigan or Texas, and you are a college student at a public school, you are protected. If your school has a bias response team, that is probably unlawful over the holdings in those courts. If you are in Illinois, kind of the Seventh Circuit, and like I alluded to, technically now there's no ruling in the Fourth Circuit, but seems likely that they'll readopt it if it ever comes up. So if you're living in Illinois or Virginia, you are not protected. You can be subject to kind of a surveillance regime that encourages self-censorship on campus. So, I mean, the circuit split is still there. It could not be a clearer circuit split. It's the exact same plaintiff suing universities over very similar, near identical policies with completely different legal rulings. So I think that here the Supreme Court ultimately just punted. I think it has to come back to the court at some point. Maybe the Oklahoma case in the 10th Circuit is another chance at that. But yeah, I don't think this is over. I think there's going to continue to be a lot of litigation over this because, like we mentioned at the top, they're everywhere. Over 450 colleges and universities in the US have these systems. If it's at a public school, it does chill speech. It does violate the First Amendment. So I think we're just going to see a lot more litigation over these in the next few years.
All right. Well, let's move into the Q&A. We've got 5 or 6 questions in here, so I'll throw these out to you. So the first one is, do you think the Department of Education's forthcoming Title IX rule will impact free speech rights on campuses in light of kind of some of the definitions? And I'll let you talk about it, then I'll chime in as well.
So so it talks about sex-based harassment. So the Supreme Court has actually commented on what qualifies as harassment that is beyond the protection of the First Amendment. And that was in a case called Davis. And of course, I don't have it up at the top of my head, but I believe the standard is that it has to be so pernicious and pervasive that it effectively prevents someone from attaining an education in the school context. So whatever the Title IX Department of Education regulations come out, it doesn't really matter because the First Amendment has precedent over what the Department of Education says. And so to the extent they want to define sex-based harassment so broadly as to cover things that are protected by the First Amendment, those rules will be challenged. And we have seen this, that FIRE has participated in those challenges before. Those rules will likely be enjoined to the extent they cover speech that is protected by the First Amendment.
Yeah, the Davis standard is severe, pervasive, objectively offensive, and deprives of an educational benefit. So it's a really high standard, right?
Yes.
And if any policy, including the new Title IX regs, if they go through without being amended, if they cover speech that do not meet that standard, then it would be unconstitutional and would be challenged. And we actually, the ADF wrote a number of letters in comments in response to the proposed regs. We have a number of concerns. We believe that they have a bunch of problems, and speech, punishing protected speech is one of those. So I do think that if they are adopted as proposed, I do think they will be challenged on speech grounds, and I think there's a really good chance that somebody could prevail in challenging those, because I think that they are currently overbroad in how they're in the type of speech they're covering.
Absolutely. FIRE's written in several comments to that effect as well.
All right. So the question about how about private universities like Harvard? So the discussion we've had today, does it cover private universities, Abby?
So this does not apply to private universities because of the simple fact that they are not covered by the First Amendment. Some people have challenged speech restrictive policies at private colleges and universities under a breach of contract theory. So under that theory, many private colleges and universities in their student handbooks and in their school policies have commitments to academic freedom and free speech that is basically equivalent to what the First Amendment protects. And so people have sued saying you made a contractual guarantee in this policy or handbook that you would effectively keep First Amendment standards at your school, and you violated that, whether it be through a speech code or a bias response team. Those lawsuits have not been very successful. I believe maybe one has been successful, was not recently, but basically these types of challenges by Speech First, I think they're only going to be against public colleges and universities.
Yeah, so there's a question about, are these bias response teams somehow responding to any federal mandate?
So as in response to things from Title IX or things like that,
yes. Mm-hmm.
They may have been inspired by that, but certainly Title IX does not require that schools have a bias response team. Usually any school that has a bias response team also has a separate Title IX office, and that would be in response to the federal mandate. I would say none of these bias response teams are required under federal law, no.
Okay. Yeah,
and that theory that defense has never been raised either by any of the schools that I'm aware of.
Yeah, they're not claiming that they have some mandate by the federal government. In fact, because free speech. I mean, speech first is saying the federal government has the First Amendment, which, says you can't do this, right?
Yes.
Yeah. All right, and so the next question is about the website designer case, whether the standing argument is affected by that. I think they're talking about ADF's case, the 303 creative case, which we won recently. And so they asked, they said in that case, the website designer desired to do a wedding website, but had not done so, fearing the state regulatory body would come after her. It's really not affected here in my mind. And the reason why is because in that case, Colorado said that the policy does apply to her speech and it would prohibit her from doing that speech. And if she did it, they would punish her for that. So that was very clear. Whereas in this case, I think it's true that Virginia Tech never said, yes, we would punish you if you engaged in the type of speech you want to engage in. Is that right, Abby?
Yes, you know more about that than me, obviously, having been part of that team, but you're exactly right. There were stipulated facts in that case that basically got rid of the standing issues that are present in speech first cases.
So next question is there any current litigation on public high schools campuses, so K through 12 campuses, that are chilling speech through bias type regulations?
I would say there are a lot of open speech cases against K through 12. I know ADF has some where FIRE has filed amicus briefs. FIRE ourselves, we also have multiple K through 12 challenges going on. One of them, I'm not sure, I believe it's been filed, but I'm not sure if it's been filed yet, so I won't talk about our specific litigation yet. But yes, there are many challenges going on at the K through 12 level, but it's a very different analysis because given that students in K through 12 are minors, they're subject to a different standard. K through 12 students do have freedom of speech, but under a case called Tinker, given the unique circumstances of teaching children and teenagers in school, it's just kind of a different environment. There are very different standards for what kind of speech can be restricted. Those challenges are definitely going on, yes, but it's not really the same analysis that takes place in the campus context where everyone is an adult.
That's right. And I've done a lot, and we've got some pending, as you said. They're not normally called bias response teams. Typically, they punish them under a bullying or harassment policy or under a Title IX. Those are the things that I've seen where they come in and they just have a general policy that, and as you said, they have a little bit broader discretion to punish speech under Tinker. And they typically say it's not normally under a bias lens necessarily. It could be under harassment or a discrimination. In the Liam Morrison case, which we have as a 7th grader who was punished or told he couldn't wear a shirt that said there's only 2 genders, they did the same thing. They essentially used a bullying or harassment non-discrimination policy to say that you can't engage in that.
Yep. And we filed a brief in support of you in that case.
You did. And we appreciate that. And we're waiting for a ruling at the First Circuit in that. So the next question, do you think Justice Jackson's view of equitable mootness as reflected in her dissent will gain any traction with the other justices? Any thoughts on that, Abby?
I don't, it's so hard to read the tea leaves. I don't think so, to the extent I don't think it's going to get traction with a majority, certainly. I think that if others were interested, they probably would have joined her. So perhaps she could get 1 or 2 other justices, but I don't think it's going to be adopted by the court anytime soon.
We've got time for one more question, I think. So somebody asked, has anyone tried using the bias response team process to address disruptions by liberals of conservative events? Are you aware of anything like that?
So let me think. I know that these cases probably exist. Off the top of my head, I can't name any. It is mostly used against, these types of policies are predominantly used against conservative students, mostly because those students have viewpoints that don't align with most university administrators. There is one case actually that I just recalled where a a number of pro-Palestinian students put up flyers that were parodying or copying what an Israeli eviction notice looked like. So they were making it look like an Israeli eviction notice, but it was very critical of Israel, and posting them all around campus. And those students were investigated by the university administration, and they were reported through the bias response team protocol. So it does happen, it has happened, but it certainly is less common than the targeting of speech by conservative students.
I think that's all the time we have. So thanks so much, Abby. It's a wonderful discussion.
Thank you.
Yeah, I will second that. Thank you so much. On behalf of the Federalist Society, we really appreciate you both lending us your time this afternoon and sharing your valuable expertise. Thank you also to our audience for joining and participating. We welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, thank you all for joining us today. We are adjourned.